Folks, let me get your attention. First of all, I'm Bo Blackburn. Happy to be back with you again today. I think this is the third time we've been together, so thank you. I take that as a sign that you don't hate me, that you've asked me back for a third time. Thanks for having me back. I want to tell you a very little bit about myself, and then I want to get a little information from you, because I think that'll help us maybe fine-tune what we're going to talk about a little bit. I'm a roughly 20-year lawyer.
Youngster.
Yeah, which is hard for me to spit those words out, but I've been doing this for about 20 years now. Primarily what I've been doing is representing brokers and agents and all sorts of legal issues, lawsuits, truck complaints, procuring cause disputes, commission disputes.
Brokers have those?
They do have some of those.
Really?
They do have some of those. I've had the good fortune to represent many of the brokers here in the state of Texas. I actually represent a broker in El Paso. Had the pleasure of representing your office. Represent folks in Austin, Dallas, Midland, all over the state. The short version is all over the state.
Broker lawyer.
I also serve, as Hank was going to point out here, I serve on what is called the Broker Lawyer Committee with the Texas Real Estate Commission. Those of you who may not know what we do, we're the folks that draft and revise the promulgated forms.
It's his fault.
Well, it's not completely my fault. Partly. It's 1/12 my fault. How about that? There's 6 lawyers that serve on the committee and 6 brokers, and then we have 1 at-large person. Actually, I want to talk to you a little bit about the broker lawyer, but before I do that, I want to talk a little bit about you. By a show of hands, how many of you have written no contracts, no 1-to-4 family contracts? So don't be, put them up. This is going to help me. Get them up a little higher for me so I can see here. Okay, and then how many have written less than 5? A good part of the class fits into 5 or less. All right, that's exactly what I was hoping we would have. So I hope this is gonna be useful for you. For those of you who've written more than 5 or maybe written a lot, this is probably going to be a review for you in terms of some concepts that maybe you haven't heard in a while. I want to tell you how I put this class together so you kind of understand where I'm coming from. I have a law firm in Austin, and I have 10 lawyers in my office, and we just hired what we call affectionately as a baby lawyer. And I asked him to go do something for me one day, and he went away, and then he came back and he says, I don't know how to do that. And I just was kind of saying, and I sat down with him to help him do it. And what occurred to me is he knew nothing about contracts, not just real estate contracts. He did not understand the basic concepts of contracts. So after I got a little annoyed, I thought, well, I got to explain to him so he understands this. And when it kind of dawned on me, if a young lawyer, I mean, he's been a lawyer for 2 years and obviously made it through law school, if he didn't really truly understand what contracts are, I bet that's not a common issue, and I bet a lot of real estate agents probably fit in the same category. So I put this material together basically modeled after what I did with my young lawyer in my office. So that's what we're not going to do. Let me just tell you in advance, we're not going to pull out the 1-to-4 and say, what is section 1? We're not going to do that. In fact, we're going to talk very little about the 1-to-4 family contract, because I think there's a precursor to starting going through the contract, and I think it's this stuff. And even those of you who are familiar with the 1-to-4, I hope you find this useful. If you don't, all complaints need to be addressed to Hank. Make sure you take it all. Make sure you take it all up with Hank. He will be happy to address any.
Love those phone calls.
A little note about Hank. My very first large broker that I represented, roughly
Long time ago.
17 years ago. For those of you who know Craig's your owner. Craig was still in production when I very first started representing the Heritage office in San Antonio. Hank wasn't even the risk manager yet, I believe. Is that right?
Actually, I was for Mark.
Okay, all right, but he wasn't his lofty position that he is now.
I was independent contractor for Mark reviewing contracts.
And I was a baby lawyer. I didn't know any of this stuff 17 years ago. A lot of what I now think I know about contracts, I've learned from this man. He has been a mentor to me over the years, who's taught me a lot about, specifically, obviously, real estate contracts. You have, the reason I want to say that is you have a tool that you should utilize, and yes, so that means I am calling Hank a tool.
Been called worse, no problem.
That you should utilize. I know he can be rough and he can be demanding, but that's because he expects it to be done right, and he knows how to to teach you how to do it right. So please use that. All right, enough about that. Enough about me. I know a little bit about you, so I want to what I've done here first is I've said the elements of a contract. And then I've written out 6 points that I want to go through. And I want to go through each one of them first, and then we'll go back and spend a little more detail on what I call the elements. And the elements, you can think of that as kind of like the elemental chart in chemistry. You know, an element is how you build matter. The same concept for contracts. You build a contract by going through these elements. And the first element that I put here is offer. That's the first element of a contract. For those of you who can see, the second one starts with an A. I bet most of you can guess that one. Somebody help me out here. Acceptance. There we go. And for those of you who can see here, the third one starts with a C. No, good guess. There we go. Consideration. That's a critical one. That's the one that my young lawyer had no clue on. The fourth thing I want to talk about is the SOF, or the statute of frauds. It's an old English law concept that's carried through today that's a critically important concept for contracts, especially real estate contracts. The fifth one is I'm going to give you a little preview, is emails. And I'm going to phrase it with a question. Can a contract be formed for the sale of real estate in the state of Texas based on an exchange of emails only? That's our question.
Yeah.
And we're going to break it down. That's okay. I like that. Nadia? Nita, hello. Sorry, I can't see that far. Nita, that's what, everybody who agrees with Nita, raise their hand.
That's
everybody who disagrees, raise your hand. Okay? And I'm guessing the rest of you just don't know. Okay. All right, we'll come back and talk about that. This is a hot button issue that we're seeing in the state of Texas. It's bubbled up to my committee, the Broker Lawyer Committee. I think we're going to take action on this summer. Don't know yet, but I think we'll address this summer. And then the sixth thing is the concept of escrow. It's not exactly germane to the rest of the stuff we're going to talk about, but it just seemed to me that I wanted to insert this concept because of the audience I'm talking to. It's an important concept. And then after we understand these elements, we're going to come in and we're going to basically build a builder contract, and then we're going to see if we can rebuild the 1 to 4 family. And then if we have some time, I'm going to talk to you a little bit about the third-party financing addendum, which is my very favorite thing to talk about, or not. It may be my least favorite thing to talk about, but we'll talk about that a little bit. Okay, I'm going to read to you some definitions, and then we're going to hopefully break it down and convert that into layman's or convert it into English. Offer. An offer is a promise, and you don't need to write this down. Trust me. An offer is a promise that is by its terms conditional upon an act, forbearance, or return promise being given in exchange for the promise or its performance. Does anyone understand that? My lawyer didn't understand that either. Okay, so let's break it down into some of its elements. And I think for me, if we wanted to break it down into one word, it would be a promise. An offer is a promise. Here's what I'm going to do. Right? Think of a promise that way. I'm going to give you X. I'm going to give you Y. And if we want to translate that into our specific context, let's start with a builder contract. And this is what we're going to kind of do, hop back and forth. A builder contract. What is the promise that a buyer or somebody who wants to have a home built, what is the promise they're making?
To pay for it.
Bingo. I promise to pay you X. That makes sense?
Yes.
So if you think about offers as a promise, and there's more stuff to it, obviously, all this other junk in here, we don't really need to get down to that level of detail. A promise could be, I'm not going to do something. Anybody think of an example of how that could be an offer? I promise that I won't do something. Hank, you see these all the time. You want to chime in?
Promise I won't take the refrigerator.
Not exactly. I promise I won't sue you. Forbearance. I have a potential action that I can take. I'm going to forbear. I'm not going to do that. So you can promise to do something, or you can promise not to do something. You can give something up. That can be a promise.
The builder designed and drafted contracts are going to be somewhat different than a tar or TREC contract.
They're a lot different.
And so the builder contract is more seller-sided than the TREC contract that would be equally.
Absolutely. Well, most custom builder contracts are incredibly builder one-sided, right? Because they're drafted by a bunch of builders, so they wanted to protect them, right? Theoretically, our contract, when I say our, I'm talking about the 1 to 4 family, the broker-lawyer contract. Theoretically, that is neutral. It's not favoring a seller or a buyer. I think maybe what you're pointing out is that some contracts, like some people would argue that the AIA builder contracts lean a little too heavily to builders. And I don't know that I subscribe to that or not, but you certainly see that in the market. Okay, so offer. Everybody, let's just think of an offer is nothing more than a promise to either do something or to refrain from doing something. Does that generally make sense? Okay, let's move on to acceptance. And I'm going to give you the example, and then we break it down a little bit. I'll give you the legalese, and then we'll break it down. Acceptance of an offer is an expression of assent to its terms. And I'm going to read the rest of the paragraph, although I'm not sure it helps much. It must be made by the offeree in a manner requested or authorized by the offeror. The offeror is the one making a promise. The offeree is the one that's receiving the offer. An acceptance is valid only if the offeree knows of the offer, the offeree manifests an intention to accept, the acceptance is unequivocal and unconditional, and the acceptance is manifested according to the terms of the offer. Again, a bunch of legal mumbo jumbo that isn't really that helpful. The first part of it is what is important. Acceptance of an offer is an expression. And think about why they use that word expression. Because the expression can mean a bunch of different things. It's an expression of assent. In other words, promise, I would like to buy your new car for $10,000.
Too low.
I don't think so. $10,000. That's my promise. I will pay you $10,000 for your car. The acceptance is some expression, right? The key word there was expression. It didn't say, they use that word specifically. It didn't say a written acceptance. It didn't say an oral acceptance. It just said an expression, which could mean both, right? And it can mean other things. It's an expression. And this is what I want you to understand. acceptance can be done in a lot of different ways. But what you're doing is you're expressing assent to the terms of the offer. Does that make sense? Is that still too legalese? Everybody with me? If you're not, this is a good time. Let's break it down. So it's some expression, which could be in multiple different ways, that I understand the offer that you made to me and I accept the terms that you proposed to me. All right. Consideration, and this is one I want to spend a little time on. The legal definition is, I'm not even going to read that one to you because I don't want to waste our time. It's too difficult. It took me weeks and weeks and weeks of contract class to really understand what it is. And I finally said, oh, it's just a swap. I wanted to say to my professor, why didn't you just say it's a swap? Consideration is a swap. I'm going to give you something and I'm going to get something in return. That's consideration. All right. Let's break that down into some examples. What is the consideration? Do you mind if I call on you? Remind me?
Okay.
Julie. You already answered part of this. What's the consideration in a builder contract?
Earnest money?
No, actually it's not. That's a term. What's the swap? What is a swap? On one end you have a builder. On the other end you have the buyer, the person who's hired the builder to build their house. So what's the swap? What is the builder giving to the buyer? A house. What is the buyer giving to the builder? Money. There's a swap, right? On one end you have the buyer that has money. On the other end, you have the builder that's given and constructing a house. That's the consideration in a builder contract. I can read you this definition, but it's just going to confuse you. It's a swap. One side is giving something to the other side, and the other side is giving something in return. What you'll see a lot of times lawyers do is like this circle here. And for lawyers, contract is K with a circle around it. So you got this consideration. You got this coming from this side. And then for this one, we could put our builder here. And then we could have our homeowner here.
Why just builder? Why not homeowner?
I'm just using this one as an example. We'll use this one next, okay? But in this instance, we've got a contract. We've got a builder who's given a home, constructing a home, and you've got a homeowner who's given cash. So if we were in a law school setting right now, and we asked you we gave you a test, what's the consideration for a builder contract? If we drew this out on our exam, you get a check mark. That's the consideration. Okay? Now let's take that. I'm sorry, what's your name? Natasha. What would the consideration be for a 1 to 4 family earnest money contract?
House and money.
You've got a seller, you've got a buyer. They want to form a contract, and there's consideration flowing from the buyer. What's the consideration from the buyer? Money, right? What's the consideration from the seller?
Property.
You got it. There's a swap. I'm going to give you something and you're giving me something in return. That's consideration. Okay? Does that make sense? It's an important part to understanding contract. Consideration is really critical. I'm going to give you an example of something that maybe sounds like it could be a contract, but it really isn't. Because if you don't have consideration, you have no contract. Out of the mutual respect and admiration that I have for Hank for being my mentor, I'm promising Hank that next year I'm going to give him $10,000. Do we have a contract?
No.
Sorry, you can't sue me.
Verbal promises.
Let's break that down. Why do we not have a contract?
It was not in an agreement.
It was a mutual agreement.
No consideration. A promise to do something without consideration is nothing more than a statement of what you intend to do. It is not a binding, enforceable contract because there's no consideration. I'm saying, Hank, next year I'm going to give you $10,000. For me to be bound to that, to have created an enforceable contract between us, there has to be some consideration flowing back to me. Otherwise, it's just a statement of what I intend to do. Does that make sense?
I want a promissory note.
Let's break promissory note down. Is a promissory note a contract? Let's break it down. So we have a contract. Okay, we have a lender. We have a borrower. Let's break it down here. What is the consideration from the borrower?
I promise to repay
Yeah, promise to pay.
over whatever term.
There's some terms. There's going to be a repayment term. And there's almost always, not always, some additional money that goes back to the lender, interest. So money, and what's the consideration from the lender? Money. That's right. That's exactly right.
Money now for money later.
Both sides are making a promise. Mr. Lender is saying, I promise you to do what?
To give you a specific amount.
To write a check to you, right? Today, when you come in and you sign what? A contract, right? A promissory note is a contract. David, when you come, what a name you have there, Mr. Osborne.
Super Dave.
Yeah. David Osborne owns about 12 or 14 offices, KW offices. So
I know, I've seen him on that. I'm trying to get into it.
you need to follow his footsteps. You come in today, David, and you sign this contract or a promissory note. I'm going to give you a check. That's the consideration. And then you do what? You promise
to make payments.
Promise to do something, whatever it is. I'm going to pay you X every month. I'm going to pay you a balloon pay, whatever it is. That's what contracts are all about. And it's really critical for you to understand contracts, to understand the concept of consideration. And I may be making it too simple, but I think it works. Consideration is a swap. It's a swap. It's a swap. It's a swap. And forgive me, I'm from West Texas. Do y'all know what a swap is? They go, is that a term? Okay.
Swapping.
Yeah. All right. Statute of frauds. And this is one I'm going to read to you just because I want you to listen to it. It's kind of goofy. The statute of frauds in 1677, Parliament of England enacted and required that certain types of contracts, wills, and grants, assignment of surrender of leases or interest in real property must be in writing and signed. Must be in writing and signed to avoid fraud on the court by perjury and subornation of perjury. It is also required that the documents of the court be signed and dated. Now let's break that down a little bit. What did you hear in there? What I hope you heard is not only a requirement, but the reason for the requirement. What's the reason for, did you pick up on there? What is the reason for having certain, did y'all hear that word, certain contracts, the important ones, wills, real estate transfers, grants, assignments. It doesn't say all contracts have to be in writing and signed. It said certain contracts. So what they were saying is some of the transactions that we see back in 1677 are a lot more important than the other ones. And we're going to require that they be in writing and they're signed. Why? Did y'all hear? Did you hear that? No, that's the standard. I think you're missing it. Why did they set that standard? Exactly. Expand on that.
Well, I guess if both parties have signed it, there's clear evidence that both parties were a part of that.
That's right. Say it the opposite way. Say what would happen if you didn't have it in writing.
Well, you have a potential for someone to write something that benefited only them.
No, you don't have it in writing. because remember what they're saying is some of these are so important, let's put them in writing, which means some of them aren't important enough to mandate that they be in writing.
They're not binding
So-
and enforceable.
No, actually, that's a common. Thank you for saying that. That is a common misconception of the statute of frauds. There's all sorts of contracts that we have in our day-to-day interaction. I mean, you probably don't even think of it, but when you pull up and when whoever ordered that food, they entered into a contract,
It's a unilateral
right?
contract.
We're going to get into that shortly, but yes. Did y'all think of it that way? When whoever got that food, they just entered into a contract. So, and there wasn't any written contract that they signed, right? So there's all sorts of contracts that we have, and what the Parliament did is they said some of our contracts are so critically important, we have to have them in writing for them to be enforceable. Which means by definition, they said some aren't that important and they don't have to be in writing. Which is what I was trying to pull out of you a little bit. And you said it exactly correctly, that if it's in writing, you have it clear, right? And you have both people that signed off of it. When it's not in writing, what can happen? And this is what the court was saying. They were saying that if you don't have it in writing, we're subject to what? The word they used is fraud. And subornation of perjury is exactly what they said. So what they're saying is, because remember, they were making rules to govern their courts. What they're saying is, if you, Mr. Buyer and Mr. Seller or whatever you are, want to enter into a contract, you want to enter into a swap, and you don't put it in writing, you can't come to us and ask us to decide your dispute. Right? People could still do it, just like they could today. If you and I wanted to sell a piece of land, we don't have to use the 1-4 family contract. We could just verbally come to an agreement, and we could probably make it work. But if I screwed you, and you went over to the courthouse and tried to sue me, our courts would say, sorry, when you want to bring your dispute to us, because remember what we are, we're the dispute deciders. If you want to bring your dispute to us, you have to comply with the statute of frauds. And if you didn't,
You're screwed.
go away. Because what they're saying is, we don't want to be in the middle of a swearing match. How are we supposed to decide, the court, what was actually agreed to if you didn't put it in writing and get it signed?
So it's like basically kind of like buying a lemon car without the paperwork for it, like a verbal agreement is what it is.
Sort of, okay? And I think that's a little bit of an oversimplification. And this is such an important point. I want to slow down a little bit and make sure everybody's on the same page on this. Because I think a lot of people have the reaction that you do. I did. I know a lot of people do. That, oh, well then, if it's an oral contract, it's not enforceable. That's just not true. Oral contracts are enforceable all the time, as long as they're not required by the statute of frauds to be in writing. We can have an oral agreement that falls outside of the statute of frauds. Let me give you a good example, and it's one that I see frequently. Mr. Hank is a house painter. I own a house. Hank comes to my house and says, I would like to paint your house. And I say, I would like for you to paint my house. Hank says, I'll charge you $10,000 to paint your house. I say, I would like to pay you $10,000 to paint my house. Great. When can you get started? Hank paints my house, and he comes and he says, where's my $20,000? I said, well, we didn't agree on $20,000. We agreed on $10,000. Hank sues me. Our courts will have to decide that dispute, because that's not a dispute that's not a contract that requires what? It requires two things. Writing and signing. Okay? So Hank can actually sue me under that example, because it's not required to be that contract that we formed, that binding, valid contract that we formed is not subject to the statute of frauds. Does that make sense? And if it doesn't, let's break it down.
Okay, so, but the 1 to 4 family contract, you have to, I'm not sure what question I'm
Sign
answering.
and date.
It has to be signed and date per the statute of frauds.
The reason that we have a written contract for you guys to utilize is because contracts for the sale of land are subject to the statute of frauds. So this has been around since 1677, right? When the people at Trek got together the first time and said, we need to help real estate agents, give them a written document that can be signed by the buyer and the seller so they can comply with the statute of frauds. That make sense? And imagine there's all sorts of contracts. Some of them, as a society, we've said these are important. When people are selling land, that's important. We want to make sure, as a society, that we put a burden and an obligation on those parties to put it in writing. When Hank and Bo contract over painting their house, not that important. Big picture. It's important to Hank. It's important to Bo, but it's not really that important to society. So that's how they kind of.
I'm good.
Because think about it. Listen, I'm going to read it again now that we've had a chance to talk about it. A statute of frauds. Parliament in 1677 in England required that certain, which means some are required, some are not required. Certain types of contracts, wills, and grants, assignment or surrender of leases or interest in real property must, and that means mandatory, must be, are two things, in writing and signed to avoid fraud on the court. In other words, we're doing this because we can't put ourselves in a position of deciding disputes over he said, she said, over really important stuff. Fraud on the court by perjury and subornation of perjury. It is also required that documents of the court be signed and dated. Does that make more sense now the second time through? Any questions on that?
Where do you find the contracts that don't need to be in writing and signed?
You have to have some training. And if you're out there entering into a contract, honestly, it's why guys like me make a living, right? You need to go to, if you have an important contract, you probably should pick up the phone and call somebody like me and say, does this need to be in writing? Because if you go out and do it on your own and it's supposed to be in writing and you didn't put it in writing, then you can't go to the court and say, court, help me out. Does that sound familiar to you guys? For those of you who have had a little bit of experience, does that sound familiar to you? Can anybody tell me what that applies to? To you? Can anybody tell me what it applies to you?
Credit cards?
Nope. Money. How do you guys get paid? You get paid when you represent a seller and a buyer. Come on. This needs to be hitting home. It's the exact concept. What do you guys have to get paid?
A license and a contract.
A contract. You have to have a contract to get paid. Does that contract have to comply with the statute of frauds?
Yes.
Yes. You all use listing agreements because you have to. I'm guessing not all of you either do use buyer's agreements or are not planning to use buyer's agreements. If you enter into an agreement, a contract, if you enter into a contract with a buyer to get you paid and it's not in writing, is it enforceable?
No.
Absolutely not. Why? Statute of frauds. It's that simple. Our courts are saying that's an agreement that at least touches on land. And if you want to come into our area and ask us to enforce your agreement, you better put it in writing. And what else? Sign. Sign. Okay? So a lot of these concepts really permeate every contract that you guys deal with, but I'm guessing you didn't know the rationale behind it. So the statute of frauds is critically important to you guys for that reason alone. Okay, any questions on the statute of frauds? Let's move on to emails. Emails, which I've already previewed the question, and I noticed you didn't weigh in.
I could weigh in a lot, but
No, I just want a yes or a no.
Don't get it started.
I just want a yes or no.
on
Emails?
Can, in the state of Texas, can the parties create an enforceable contract for the sale of land through emails?
Yes.
Emails only. Let me make it real clear. Hank, I'm a buyer, or I'm an agent. Hank's a seller, or he's an agent for the seller, and Hank and I send each other back emails only.
Yeah,
Can we
without
do
verbal
that?
Agreements? You mean without verbal, right? Just through email.
Just through
Sign and
emails.
date.
Just through emails.
Yes.
What's the answer?
there have been a few.
No. Can you or can you not?
No.
Yes.
Yes.
You
Hank is correct. Yes.
Title company.
And it is extremely dangerous. That's why you have to be so
Hank is-
careful on how you structure those emails.
Hank is correct. There is one case that I'm aware of in the state of Texas that allowed an enforceable contract to be formed through an exchange of emails only. Now, y'all know what I mean by emails, right? I'm not talking about attaching a contract. I mean an email. In the body of an email, I represent the buyer. Hank represents the seller. Hank, my client will pay X dollars and we'll do blah, 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 blah. Hank writes back an email and says, my client accepts. Y'all with me?
Yeah.
That's what I'm talking about. There is one case that is found that under certain scenarios and certain circumstances that the parties, and did you notice what I said? I represent the buyer. Hank represents the seller. It's not even the buyer and the seller, right? It's the agents. There's one case that is found that can form a binding contract. How? You should be saying how. The statute of frauds should present that, should preclude that, because it doesn't sound like it complies with the statute of frauds. So what are the two things about the statute of frauds?
In writing.
In writing
Sign.
and signed. So the courts analyzed our, God, is that 300, 400, 400-year-old? 400-year-old concept and said, can this scenario comply with the statute of frauds? First thing, is it in writing?
Yes.
It is in writing. Yeah, done. Check. Second thing, is it signed? And it has to be what? Signed by who? Could I sign on behalf of my client? Does it require that the parties, does the statute of frauds require that the parties sign? I believe it does. I believe it does. So this particular court said we have a writing because emails are in writing, and then they applied the uniform. Oh gosh, I should have looked this up. There's a federal statute that is actually one of the reasons that allows you to have DocuSign. It's the Uniform Standard something Signature Act. It's a federal act. I'm not one of those lawyers that memorizes this stuff. My mind doesn't work that way. Forgive me. But there's a federal act that says a electronic signature can act as a wet signature, basically, right? I mean, that's how DocuSign works, right? So the court took that federal statute and said, can an email itself constitute a signature? And it went through a long examination of whether or not what could constitute a signature. For those of you who have typed out your name and put it as what is that called? A foot in your emails. What is that called? Signature. Yes. For those of you who have those in your email, that can count as your signature, right? So, well, it's a good concept to put. I have it on mine, right? I have it on mine because you want people to know who you are. You want people to be able to contact you. Realtors want people to be able to contact you, right? I'm the same way. I want people to be able to contact me. So I have my signature on there. And the court said, okay, we've got a writing, we've got a signature. but the only thing we may not have is the signature of the parties. And then they analyzed in this one case. Have you read this one?
Well, I know why they came out with that article a few years ago.
Yes. What they said is normally an agent can't bind their principal to the purchase. They normally can't do that. There has to be some really unusual circumstances for an agent to be able to bind their principal, their seller and or their buyer. And what they said is that the parties, the buyer and or the seller, must have absolute knowledge, unequivocal knowledge of what their agents are saying and doing. If the parties know exactly what their agents are saying and doing, then we can have a contract formed, an enforceable contract formed through emails. So then they went and looked at that particular case, and the parties were copied on the email flow between that buyer's agent and the seller's agent. Okay, so they said, sounds like we actually have something that complies with the statute of frauds. We've got it in writing. We've got electronic signature, although not by the parties themselves, but the parties were copied on the emails. And they thought, sounds like it complies with the statute of frauds. Now, I personally don't like that. I don't think that's good law, but one thing you may hear lawyers say all the time is bad facts make bad laws. I think this is a really good example of that, because how many times are you going to negotiate a deal on email with the other side where both your client and the other client are going to be on the emails? Pretty rarely, right? I mean, that doesn't happen very often. Right. So we had a scenario where you had very unusual facts applied to, because we had an offer, we had clear offer, clear acceptance. I mean, the email back from one side said, yes, we accept, we'll do it. There was consideration. It complied with the statute of frauds. The court said binding. Very strange. How many of you have seen the little disclaimer underneath the signature line on emails that basically says something along the lines of, this is for the purpose of information. This isn't binding. I can't bind. This is not intended as a binding contract. Something like that. Have y'all seen that here? Is that coming around here?
Yes.
Pay attention to that. And you may, if you're like me and think it's a bad idea that you can form a contract through some emails, you may want to incorporate some language like that. Hank can get it for you. If you don't have it, let me know. I'll get it.
Yeah.
Okay, which I do in almost every class I teach. I talk way too much because we're going to run out of time. But any questions on emails? Yes, sir.
Did both of those parties have to have a listing agreement and buyer's rep agreement, or did that not weigh into the decision?
It did not impact that particular decision. Anything else?
We should just not do that.
I would strongly, if it sounds like I'm advocating for that, well, I'm not. I'm warning you, don't get yourself in that situation. Don't do that. We want to do the traditional, from my perspective, you can chime in and correct me if I'm wrong. I think we want to have a traditional exchange of a written offer and an acceptance of that written offer by the parties, not the agents, accepting.
Does it have to be doesn't it have to be communicated after that? Doesn't it have to be communicated to everyone after both parties have signed it?
You mean the acceptance?
Yes. Except once it's signed, dated, then it has to be communicated before it's a binding contract.
That's the idea. That's the idea. But when you, for instance, let me give you a for instance. That's generally true. Okay. And one thing that I read about acceptance that's important to what you're talking about, acceptance of an offer is an expression of assent to its terms. It must be made by the offeree in the manner requested or authorized by the offeror. So what do we see that applies to that? I think an example of that is buyers who write into their offer must be accepted by blah. Must be accepted by 5 p.m. Friday, March 3rd, right? So the offer is made it explicit how it can be accepted. And if it's not accepted in the manner that the offer is made, then it's not acceptance. So yes, what you're saying I think is correct, but I can see some scenarios where it may not apply exactly the way you said it. But you're generally correct. When you accept, you need to communicate that acceptance to the offeror. You're right about that. Does that make sense? Anything else on emails before I move on? And I'm going to probably skip escrow because we're going to run out of time. Okay. What I really wanted to do was shoot through this in about 20 minutes. But as I normally do, I talk too much.
That's an attorney for you.
Yeah. And then I wanted us to build, I was pretty ambitious. I wanted us to build the builder contract and the 1 to 4. We're not going to have time to do that. But what I want to do is focus a little bit on the third-party financing addendum. And I'm going to pull mine up because I can never remember. And I want to focus on approval of financing. This is one area that I think is very, very commonly misconstrued or misunderstood or maybe not fully understood. And it's one of the areas that we get questions a lot on the Broker Lawyer Committee. Why can't you guys make this easier? Why can't you do a better job of explaining this part of it? Anybody ever felt that way? Let's just break down big picture. And I still, every time anybody asks me a question, I don't know if Lori's ever called me, whenever I get a question on third-party financing, I have to go back and I have to read it, which should tell you it is a little confusing. Okay? All right. So big picture, bless you. Big picture, let's kind of break down. And does everybody generally know what I'm talking about, third-party financing addendum? Under page 2 of 2, under section B, which is 6B. It's broken down. The first thing we do when we're breaking down the options, and I want y'all to remember, these are options. We're breaking down options for you to choose, is we break it down into 2 separate categories. And the first one we just changed, I think last year, maybe a year and a half ago. It used to be called lender approval, okay, which I think we thought was misleading, and we changed it to buyer approval. So that's the first check. This contract is subject to buyer obtaining buyer approval. Let's break that down. This contract is subject to buyer obtaining buyer approval. What does that mean? That means that if you check that off, the seller is giving the buyer an out. Does everybody understand that?
Yes.
So if you don't check that, what does it mean?
They don't have an applicant, regardless if they're or not.
No?
So they can get the financing, they can get out of it?
Hold on a second. There's 2 big, and this is, please ask, okay? There's 2 parts to B. The first one is buyer approval, and the second part is property approval. And financing can be contingent on both, can be contingent on neither, or it can be contingent upon one of those 2. Does that make sense?
So you can check both those boxes.
Well, you can uncheck both of them, okay? Right, and this is confusing, right? This is why I wanted to talk about it. So you can check this contract is subject to buyer obtaining buyer approval, which means the seller is saying, Mr. Buyer, I'm going to give you an out. I'm going to give you some period of time to go see if you can personally get approved. If you're dough, that you can go to a lender and say, Mr. Lender, I have this amount of dough. Lend me money. You can go, I'm going to give you an out to go figure that out with your lender. And I'm going to give you X number of days for you to go figure that out. So that's the first thing you have to decide as the seller. Do we want to give that buyer that out? Because you can give it to them. And under B1, the first sentence says, this contract is subject to buyer obtaining buyer approval. Then if you scroll down a little bit, it says, this contract is not subject to buyer obtaining buyer approval. So what are you saying if you check that? Don't bring me a contract if you haven't already gotten approved. If you haven't already gone to a lender and figured that out yourself, don't waste my time. I think that's what you're saying. Anybody seriously? Anybody disagree? Let's hear it. Let's get it out there.
That one's called what?
This contract is not subject to buyer obtaining buyer approval. So you have the first decision that you have to make, whether you're the buyer or the seller, is are we going to give the buyer an out to figure out if a lender will lend to a particular buyer? Everybody with me?
Yes.
Okay.
And this has nothing to do at this point with property condition.
Correct.
Okay.
Okay. Because we've got 6B1 buyer approval, 6B2 property approval. Okay. And they are separate and distinct concepts. And if you can think of them as separate and distinct, it makes understanding the third-party financing addendum almost possible. Y'all are supposed to laugh at that. Come on. Okay, let's look at, so everybody with me on the first part. Buyer approval. The first thought is, are we going to give them an out? Or are we not going to give them an out? The second concept that's really important on both sides. It's really important on the buyer side. It's really important on the seller side. If we're going to give the buyer an out, how much time are we going to give them to go figure out if they can get a loan based on their own dough? So we left you guys a blank in here for you to negotiate because it should be an honest negotiation. Okay, that's the buyer approval. The second part is property approval. Okay, and let's read this one. Property approval will be deemed to have been obtained when the property, did y'all listen to that? Property approval will be deemed to have been obtained when the property, says nothing about the buyer, has nothing to do with the buyer's finances, has satisfied lender's underwriting requirements for the loan.
With no timeline stated.
I'm getting there. Including, but not limited to, appraisal, insurability, and lender required repairs. So they're telling you that underwriting requirements are a lot of things, but the ones that we decided to draw out are those three: appraisal, insurability, lender required repairs. If property approval is not obtained, buyer may terminate, which sounds fair, right?
Yeah.
As long as the seller grants that right to the buyer, it sounds fair. Sounds like we don't have any problems. Sounds like this should work smoothly.
Right.
Hold that thought. Buyer may terminate this contract by giving notice to seller. Well, of course, they should give notice to seller. Obviously, that's the right thing to do. Before closing. That's the problem. Before closing, and the earnest money will be refunded to the buyer, which sounds legit, right? That's a negotiated item. That's exactly what should happen. What's the hiccup in there? What's the problem? We have a market problem that's almost impossible for us on the broker lawyer committee to fix because we have lenders that are not finishing their review of their underwriting requirements until the day before closing.
Really?
3 days.
3 days now, maybe. Yes, you're right.
Sorry, we're going to need another week.
You're right, right? So as the committee, we could put a blank in there, and people have asked us to put a blank in there, and there's an argument for a blank to be put in there. We hadn't gotten there yet. So what we have now is the buyer having an out right up until the second before closing. How many of you have experienced a buyer backing out the day of closing or right the day before closing? Is that fun? Do you enjoy do you enjoy going to your seller?
No,
Do you take the name of those people in Austin in vain when you say?
I think about whether I look good in orange or not. But,
Okay? What's our takeaway? There's got to be a takeaway. Okay? The takeaway is when you're representing the buyer, it's a pretty good thing. Pretty good thing for the buyer. It's really powerful for them. When you're representing the seller, what do you have to do? What do you have to do? And I would argue that there's almost nothing you can do to protect them. What do you need to do to protect yourself? Remember, I'm here teaching for you guys. Set expectations. You have to set, for those of you guys who haven't had this experience, go talk to one of the ones that have. It sucks. You're furious. Your seller's furious. The buyer's pissed off too. The title company's mad. Everyone's mad.
Seller's already moved out.
The seller's already moved out of their house. It sucks. And who are they mad at? You. So how do you avoid that?
By explaining it to them.
You have to tell them when you're going over this, Mr. Seller, I'm going to circle this part right here or highlight or whatever. Lori may not want you writing on the contract. Take out your highlighter and highlight that part that I read. It says, before closing, highlight that and say, I need you to understand something. If you give them this right, this is possible. It's possible. Am I saying it's going to happen? No, it doesn't happen very often, but it happens. So you need, Mr. Seller, you need to understand what you're giving them. That makes sense? And then if it happens, how can they be mad at you? I mean, they will be just because you're the punching bag, but they can't be legitimately mad at you at that point. Okay, I've already gone 5 minutes over what I was supposed to do. I really wanted to hit on escrow a little bit. Can I do it? Okay, all right. And if you need to leave, you're not going to hurt my feelings. I want to talk to you. I want to talk to you. Now, if you've got a listing appointment, go take your listing appointment and present Seller Shield to them, by the way. The concept of escrow is really important to me because I had an experience. I represent title companies not as much, but I represent title companies too. And I had a trial last year or 2 years ago now. They all run together. And what I learned in representing the escrow officers and frankly the executives in the company that I represented is they didn't know what escrow means. They couldn't explain. I was getting them ready to testify. And I said, okay, you're going to have to explain to the jury what escrow means, right? And I said, okay, let's practice it. And they were like, It is a concept that's really important for you to understand because it's such a critical concept of the 1 to 4 family contract. And it ties into the swap. Okay, and seller. Okay, here's our seller and buyer. Okay, I think you were on this one. The consideration in this one is the buyer gives money and the seller gives really 2 things. The actual house itself and what else? What do they get at closing?
Title.
Bingo. They get a piece of paper that says it's theirs.
If paragraph 5 and 6 stated.
That's right. That piece of paper is really important. Otherwise, they just are living there, right? So the concept of escrow really ties into the swap because the escrow person, office, whatever you want to call them, the escrow officer, the title company, whatever you want to call them, what they're doing is they're helping you do the swap. An escrow agreement is a contract, right? It's a contract. And what you're doing, you as collectively as the party, is you're saying, here's our 1 to 4 family contract. Well, who's y'all's title companies here? Who's the big one? First title. Will you serve as our escrow officer? First title says, yes, I will. What are they really doing? They are, other than selling the title policy, which is very different than their escrow function. What they're doing, that's the title. That's the title part. The job of an escrow officer or an escrow agent is to take stuff into possession and then deliver it per the instructions of the escrow agreement. And I bet almost none of you have ever thought of the 1 to 4 family contract as an escrow contract. Probably never thought of it that way. It's exactly what it is. It's an agreement between the buyer and the seller and the title company. And the title company, when they accept the contract, agrees to be bound by the terms of the 1 to 4 family contract. What are they physically escrowing? It's the swap.
Yeah.
It's the swap.
Yeah.
They're getting the money from the buyer. They're holding it in what? Escrow. They're getting the deed prepared, and they get it from the seller, and then they're holding that deed. And then at the appropriate time, they do the swap. So that's why, and I know it's not exactly the same concepts, but that's why in my head I wanted to talk about it at the same time. Because when I started thinking about what is the consideration for our contract, I thought, well, hell, the escrow is really, really important component of understanding our contract and how critical a role they play, just as the escrow agent, which has nothing to do with the title part. The escrow can be completely separate. In fact, as Hank pointed out, there's 2 paragraphs in our 1 to 4 contract that deal with the concept of title. One of them does that. Is that 5? 6. See, he's still teaching me. Title is 6 and escrow is 5. The first thing in paragraph 5 is you identify, the parties identify who's going to be the escrow agent. Have you ever noticed that it doesn't have to be the same one? If you choose to, and this happens, you represent a buyer, you represent a seller, and what you decide to do is because the buyer is my aunt. The aunt wants me to be the escrow officer. I'm not a title company. I can't issue a title policy, but I can still be the escrow agent. So in paragraph 5, y'all would write Bo Blackburn, escrow agent. And then, what'd you say, first title?
Yeah.
First title would go in paragraph 6 to be the title, provider of the title policy. So the escrow function is a really poorly misunderstood part of the 1 to 4 family transaction in the state of Texas. That is, again, goes back to where we started. It's all by contract. Okay, I've already gone way too long. Anything else you want me to hit on?
Everything.
We really wanted to go through the whole 1 to 4 family contract. Sorry, everyone.
Okay.
But we don't have to do that because it's intimidating.
Well, let's do this. Let me make a suggestion.
I mean, I don't know if all of y'all feel like, I don't know, shut up.
No,
Sorry,
Nita, no, you raise a good point, and I think I felt like, because of the experience I had with my young lawyer, that we needed to start here.
Yes.
And
this
if you
was wonderful.
And if you start here, and then you start going, then you go through the contract and you go, aha, that's why that's there. Why do we have to mention the escrow officer? Well, because they facilitate the swap. That's why Trek put in the escrow officer. It wasn't to enrich the title companies. We actually had to have a purpose for an escrow role in our contract. Why do they put in why is there a place for the buyer and the seller to sign? Because we have to comply with the statute of frauds. Why is there a place in there to deliver notices? Because we want the terms to be accepted explicitly in a way that we put in the offer. And the offer says exactly how you're supposed to communicate. There's a paragraph in there that talks about notices. That's why that's in there. There's a reason, maybe not a great one, but there's a reason for every particular part of the 1 to 4 family contract. And Hank and I would be happy to come back sometime and do what you're talking about, which what I wanted to do, I want to get a big old huge whiteboard, and I want to what I would love to do with you guys is to describe the swap. And then after we've really described the swap, then go and pick out the paragraphs in the 1 to 4 family contract that are going directly to the swap. And then I kind of wanted to build it that way. And then you'll see that there's almost not much left over.
Can you explain to them the necessity of what the TREC rules are when it says about putting the owner's information notices to buyer and seller? What is allowed or what is prescribed or what are they supposed to put there as per TREC? Do they put all the buyer information?
Oh, you mean in the contract itself?
Yes.
Paragraph, Hank? 21. Yep. Okay. It's a little bit of a tough question, right? Because do you want stuff going directly to your client who may or may not read it?
Right.
Or do you want stuff coming to you? I think it probably makes business sense for the stuff to go to you. But let's give an example. I've had a really ugly lawsuit over this particular issue. And it had to do with the title company delivering the HOA docs to the seller. And the contract in paragraph 21 stated a particular way for notices to be delivered. And I can't remember if it was to the agent or to the seller itself. I don't remember. And the title company did the opposite. Let's just say the contract said it should go to the agent, and they delivered it directly to the buyer. They didn't comply. That means that the seller didn't comply with the contract, because the contract tells you exactly how to deliver information to the other side. So in that particular case, the buyer was, and it's been several years, the buyer didn't have the argument to get out of the contract because the documents weren't delivered the way they were supposed to be. Or no, that was the opposite. Now it's coming back to me. The seller didn't comply with their requirement of delivering the HOA documents because it was sent to the wrong place pursuant to the contract. Therefore, the buyer did have an out. That's what it was. That's exactly what it was.
I have a really good example on this.
Yeah.
I just had it. Through the title company, I represent the buyer. We put a contract for the land. In the land, it was specific. How did we put it? We can, if the lot don't fit the architectural plans for the house, we not buying the lot. Or something like this, but more proper, right? The seller agent didn't put seller's information in paragraph 21. She just put it his name. She didn't put it nothing else. Well, I put it on the buyer's information, everything. The title company take care of it. It's exactly happened. The house didn't fit the lot. We send the termination and release of earnest money to the buyer because we're under option. We waited for money 2 months to get the money back. And the title company, then I called, they said, what is the problem? Because everybody was attached to email, even the buyer and the seller's email on an email. But the title company said, because on a notice, I need is a buyer agent. I need to I need to send him personally to his email or to his mail address to get my money back.
Yeah.
Which I said, the title company, even though it wasn't on the contract, it attached his email to all the people, and we got our money back. And Robert from Security Title, he said, you always need to put information in the notices to protect
you absolutely need to put something in there. It's a question of whether you put yourself or your client. Do you have a policy?
We don't.
Hank, do you guys have a policy in San Antonio?
Well, here's the issue. The contract states that notices are effective when delivered by and then to the parties. A lot of agents on the other side do not want to fill that out. their mindset is, oh, I don't want the buyer to know how to reach my seller because I don't want them making deals on the side I'm not
Right.
aware of.
Right.
So you have an issue where sometimes the other side will refuse to fill out that information. Now, as far as Trek is concerned, if it is delivered to the other side's agent brokerage, that is deemed deliverance to them, but that could delay it being sent to the party it needs to go to for a day or two, which might affect a certain timeline that is required. So that's the issue. Even if it's blank, it can be sent to the agent.
Per Trek.
Per Trek.
But not necessarily per our courts.
Now, TAR comes out with a lot of different articles. Now, I don't know if you get those automatically. I have my website tagged to where whenever a legal article comes out, it is sent to me. So I get those on a weekly basis. I don't know if y'all really get those kind of articles from TAR, but they have legal articles that they're constantly coming out with. And they have tons of them on their website. Pick a category. They've got tons of information there. So that would help y'all somewhat about knowing certain issues of the contract.
Now, what about on section 24, buyer's attorney, seller's attorney? What do you want them to put in there if they don't have an attorney? NA?
Yeah.
Okay. But put NA, don't leave it blank.
I'd put in A.
Okay.
Well, if they don't have, whoever doesn't have one.
Most don't because they don't want to pay any money.
The vast majority will be in A. Vast majority.
Okay, so we have a contract, you and I was the party to execute it, but I did not contact you to let you know we had an executed contract, and we've got option period going. How does that affect you and your buyer?
Okay. This is not going to be a satisfying answer.
Oh, no.
Okay. Because when people ask that, they expect me to be able to say, here's the answer.
Right.
And unfortunately, I can't give you that answer because the only way to get that answer is to file a lawsuit. And then when you file a lawsuit, if I file a lawsuit here in Corpus Christi, we're going to have a certain jury show up. If I file that same lawsuit in Midland, Texas, we're going to have a very different jury show up. Jury in Midland is going to be uber conservative. Okay? The jury here is not going to be quite as conservative as the jury in Midland. The judge in Midland is uber conservative. The judge here, no, not so conservative. And we may end up with the 12 most conservative people in Corpus Christi on our jury, or we may end up with 12 lunatics. Okay? So there is no definitive answer, and it also depends on why. It depends on why.
What if the agent just forgot?
Okay, that's going to be one thing. Now let me give you an example. The agent is at their client's house. They get it signed. They're going back to the office to fax it to the other side. And on the way back to the office, they get in a bad car accident. And they don't have any staff. They're a single agent, and they're in the hospital for 2 weeks with a coma. What do you think a jury's going to do with that compared to an agent who just forgot, right? Yeah. A jury's going to be much more likely to give some leniency to the party who's been sitting in a coma for 2 weeks as to the agent who's just lazy.
Okay, let me make a comment on this. This is kind of going to be generally speaking. If the agent doesn't notify you, but all of a sudden you get a copy of that contract from the title company, I would deem that to be the execution date. And if there is an earlier date on there which affects your client's timelines, I would notify the other side, this is the first I'm hearing about it. The effective date needs to be changed too.
Yeah. But Lori, I wish I could give you a better answer. My dad gets mad at me every time I give him that answer. But
He's
my
an
dad's
attorney.
my dad's a broker in Austin. But that's the truth. There is no book I can open and say, Lori just asked me that question. Here's the answer. Contract questions can only be answered with a judge or a jury.
Now, so we're going to go back to when you were speaking about emails. What's the takeaway with are we going to be
The takeaway from the email,
and text messages nowadays?
text messages would almost certainly fit in the same category, okay? But the biggest difference, and I don't think a text would have worked under that case, because most people, some do now, most people do not have an electronic signature on their text. So if you were doing that via text, it doesn't comply with the statute of frauds because there's no signature. Okay, so but the takeaway, there's two takeaways. Number one, we're working on it. We're slow, but we're working on it. Number two, get that disclaimer from Hank. And if you don't have it, just get in touch with me. I would put that on your emails, unless you're okay with forming a contract via email, which you shouldn't be.
No.
Okay. Can I talk about contracts for a minute? My role, my responsibility, my obligations as risk manager is to make sure that this brokerage, our agents, and our clients are protected by making sure that the contract and required addenda, everything that is required by TREC, is in dot loop and everything is structured properly. I can only clear less than 1 in 10 contracts the first time I see them because they're liable to be incomplete, boxes aren't checked, addendas are not attached, addendas are not complete, and all of this can have ramifications on the contract itself. So it's critically important that I get these executed contracts as soon as possible. I'm getting so many that are submitted the day before closing, a week after closing, and I can't clear them because they're in violation of the Licensing Act as far as the agents go by not disclosing or not showing certain information. Now, he's given you the concepts for y'all to truly understand all the aspects of the TREC contracts would probably take a minimum of 2 4-hour classes. It doesn't matter where you took a contract class, internet or through the board. There is so much that isn't explained, isn't talked to about the agents for y'all to really be understandable about all the aspects of it. And I've got to admit.
Can I stop you just for a second? Which is why I didn't attempt to tackle it in a 1-hour session. It's not doable.
Oh, so true. Where was I? I don't know. Generally.
Oh, you were talking about contract in general.
Yeah, there is so much to it. And unfortunately, when we get busy, we sometimes get a little careless. Probably not intentional, but things are missed. Most good real estate agents are great in certain aspects of the real estate industry. Number one, being an extrovert and having a good schmoozing personality. That is the biggest thing you've got to do to be successful so that you have a rapport and you have clients like you. And it's really critical that clients like you. Yeah. We have had clients that got jacked over basically, and they have gone to an attorney and they have told the attorney, make sure my agent is not involved in the lawsuit. which is a great benefit. So one of the rules of the game is make your client like you. Be professional. There's no way to go over an offer with a client in 5 or 10 minutes. And now, with all these e-signatures, they're just being emailed out and saying, do this, do that, do the other. But are you talking to them on the phone? Are you communicating with them about all the different aspects of the offer?
Will you tell them what the repercussions are for not doing their job in that format?
Well, I can address it a little bit and then follow up.
He'll see you in court.
What happened? Well, that is the repercussion. It's not necessarily a cause and effect. I don't think it can be. Can be. But what will happen when you don't do what they're suggesting is when I get them on the stand in front of the jury and I say, your agent explained this to you, didn't they? I mean, didn't they go over the contract with you? No, they sent me an email and told me where to sign. That's what they say. And then their lawyer has the email that you sent to them and asked them how to electronically sign it. Well, didn't your agent call you? Nope. All they did was send me this email.
And that goes for addendums, attachments, everything.
So let's talk about that. What should your email say?
Do you understand?
Per our discussion and per going over the contract.
Per our earlier conversation, right? Here's the contract, and then what?
Please review. Do you understand?
Call
Y'all are all
me.
getting it. Per our conversation is how it should start.
Please review.
Please, I would prefer the word read.
Yeah.
I would prefer the word read. That's kind of taboo. When I first started taking depositions 18 years ago of the parties, I would say, did you read the contract? And they would look at me like I was crazy. Of course I read the contract.
When you take a
Now-
listing,
Now when I take a deposition and I say they read the contract, they look at me like I'm crazy and say, hell no, I didn't read it.
when y'all take the listing, it's a good idea to give them a copy of a blank contract to go over it with them so they are more comfortable when they get an offer.
They're taught that to put that in their pre-listing packet. And they're also taught to follow every single conversation that they have on the phone with their clients in any form, that they have to follow up with an email reiterating the conversation and if they're in agreement with that
Okay.
conversation.
So
Sure, yeah.
let's finish that email. Per our conversation, please read. And then the final thing, if you have any questions,
Or concerns.
please, please, please call me. It's really important to me that you understand this.
And or your attorney.
Right.
We have a lot,
No attorney.
we have so many transactions now that are not face-to-face like they used to be before electronic signatures. And that is creating a lot of issues, complaints, and lawsuits. And it's unfortunate, but welcome to the 21st century in technology. Y'all have no idea how much easier it is for y'all, but it's riskier for y'all because of the
True.
technology.
Very, very true.
Now, Trek is going to require that you have complete documentation in your file. So, yes, we have the contract and all of that goes to the title company, but so much of what we are obligated to do are other documents, notices that are not part of the escrow, but are required by Trek and the brokerage to be in your file. Any important communications should never be over the phone. They should be an email, something that can be documented. So if you ever get caught up and you have to go to trial, you have the sequence of events to show them because that's what he's looking for.
That's how they're taught.
Make my job easy. Come on. Come on. I want to win these trials.
Document.
Hey, we've gone way over. Thank you guys for having me back. Very much appreciate it.